Hi everyone, welcome back to World Class Inventors. This is video number 28 in the series, and today we're going to start a completely new topic. The prior 28 videos that I've done have been foundational. They've been about ideas, why you should want to become an inventor if you have an idea. And it's been basically boilerplate. It's been ground floor information on what you should consider. Now, I did get a little bit advanced in the sense that I did some provisional patent applications and how you can physically go on their website and do it. And I showed you what my provisional patent application actually looked like for a tangle-free flag that I now have in the patent office as a non-provisional. So it was just some perfunctory information on inventing, and it was just really about getting your beak wet. Today's video is going to be an introduction, but we're going to get into non-provisional patents. Those are the patents that really count. Those are the patents that can protect you because, as I said, the non-provisional in a great measure does not protect you at all. All as it does is give you a date certain or a priority date documenting your broad-based idea from which to go off of and file a non-provisional patent application. You're really not going to be able to defend your provisional patent documentation. And the reasons are simple, really. The office doesn't require you to supply drawings, which you have to with a non-provisional if you're actually developing something that can be shown in a pictorial fashion. First and foremost, you're not going to be filing any claims on a provisional. And I really don't recommend whatsoever for you to put your claims in with a provisional patent application. And your specification is going to be kind of broad. It's just going to be the documentation of your idea. Now you're going to have this year's time in front of you, this 365 days, to reserve your place in line, because a provisional patent application is really just a placeholder. It's to hold your place in line from which to file your non-provisional. Now, those 365 days cannot be extended. This is one of the few instances in the patent office that they don't offer you an option. They don't offer you an option to pay them an additional fee, which they love to offer in virtually every circumstance. So after 365 days, your provisional will have expired and you cannot go off of it to file your non-provisional. If somebody is thinking along the same lines as you, or let's say you've developed a product out there and they've seen it because you've been selling it on the internet, or maybe a flea market, or maybe you have your own website, or you're on Etsy or something like that, somebody else might already have filed a provisional application based upon what they've seen, your physical item. Now, they can't tell whether you filed a provisional or not. That is not disclosed by the office. However, should you not file your provisional application before the 365 days are over, their documentation of their idea based upon what they've seen your finished item moves ahead, and it might actually replace what you have, meaning your provisional, since you didn't follow it up with a non-provisional. So if you file a provisional patent application, the point that I'm driving home is this: you should be serious enough to follow it up with a non-provisional. Okay, so we're going to talk about non-provisionals. I have a few things I jotted down. We're going to do a deep dive on it. So I'm going to get into lawyers, the different types of lawyers, meaning there's patent prosecution attorneys, patent attorneys, intellectual property attorneys, and patent agents. We're going to get into the various different distinctions, what they charge, what you should know about their fee schedule, what your responsibility and your involvement should be. The other wild card in this whole operation is you. You as a private citizen, as a non-registered lawyer or agent that has to be registered and certified and recognized by the USPTO. They take a test to be able to do this. And if I can recall properly, that test is about 5 days. You can file your own patent application. Much of what I'm going to be showing you, you can do. The last part of the patent application, which is the most critical, is the one with the claims. And that's where I highly advise you get somebody skilled in this art, meaning an attorney or a patent agent, to help you construct and quantify your claims. Other than that, you can do most all of it yourself. I'm going to break it down and talk to you about patent figure illustrators. We're going to get into the U.S. Code, the Uniform Code. These are federal laws that govern the formation and the protection of patents. It comes under USC 35. I'm going to show you where you can find these laws. I'm going to take you on a great website that has the Uniform Code, and we'll go through the important aspects of the law that you should know. You definitely shouldn't leave the lawyerly stuff up to the lawyers. In this day and age, with the internet, we can all be proactive about anything that involves our life, whether it be our health, medicine, vitamins, herbs, money. Everything is grist for the mill now that we have the internet. So you should be cognizant of the law. Actually, it will help you understand what your patent does, and it will help you frame out the legal four corners of your patent when you begin to draw it. So we're going to get into the strengths and the weaknesses of patents, because patents are not bulletproof. I know they've been served up to you to be bulletproof by the voices out there, especially by the USPTO and the different lawyers and legal websites you see out there that are hawking and touting that they can get you a patent for X amount of dollars. I want you to understand something. A patent, for all intended purposes, is a stop sign. It's a blinking stop sign, and it says, hey, to all would-be other people who are interested in your idea or people who want to trespass against your idea. It's saying, hey, I have a patent, hands off. This is protected intellectual property underneath my claims for 20 years. But we know in life that people break into homes, they break into cars, and they run stop signs. So if the corporation or the individual decides to run your stop sign, They're going to do it. And then your remedy is a cease and desist letter, which I already mentioned in a prior video, and I'll get deeper into it in this video. Basically is going to be worth little to nothing depending on how big the corporation is, because they're going to tell you that your patent is not worth the paper it's written on. Now, I'm not trying to discourage you. Patents are very important. They serve a purpose, and every product developer, every marketer, every salesperson of a product should want to have a patent. I mean, who's to say? Over 500,000 patent applications, meaning non-provisional patent applications, are filed in the United States of America each and every year, and those numbers only increase. So there is a value to patents, but it's only part of a balanced intellectual property portfolio. There are other mechanisms that can protect your intellectual property as well, and they are trademarks, service marks, trade dress, trade secrets, which we'll get into, inventors' notebooks, documentation, and a combination of all these things. I just want to come across and give you the realistic information on patents. And that's why I'm going to do this, and that's why I'm going to do a deep dive on it. Because I have 2 patents under my belt at present, and they both, over time, matured into category changers or benchmark patents. So I'm a big believer in patents. But my patents have been tested. I've been involved in an intellectual property conflict with the 18th largest corporation on planet Earth. I know a little bit about patents, claim construction, the federal rules of civil procedure, and so forth and so on. I just don't want to be one of those other voices out there that tell you, yeah, go ahead and get a patent. It's the greatest thing since sliced bread and you'll be bulletproof. That is a lie. That is the furthest thing from the truth. And I understand about these things firsthand. And that's why I've decided to do this particular video series on non-provisional patents. And for anybody who's doubting my intentions, I have a non-provisional patent application in the office right now that I want. I want it to get granted. So I'm not throwing the baby out with the bathwater. I just know what my patent will be able to do for me and what it won't be able to do for me. So I don't have any unrealistic expectations about my protection. Remember, patents are issued under federal law. If there are to be any disputes, and I know the Patent Office loves to tell you that there's patent court and there's arbitration and all this other happy nonsense, in the final analysis, you won't be able to afford paying for any of that. And the final arbiter of the strength or the weakness of your patent is going to be in federal district court. So that's the bottom line. So we're going to get into my book in the next video. I'm going to be reading you excerpts of it. We're going to be getting into marketing. We're going to be getting into the foundation of patents and why you should do it. We're going to get into marketing trends, and we're going to take this from the very beginning. I'm going to walk you through the non-provisional patent application aspects. And of course, we'll go on the internet and the whole ball of wax during further videos. So I guess the next few to maybe several videos going forward. I'm going to be devoting my time and my energy on sharing with you what I know about non-provisional patents. And I hope I can do this in a way that you haven't experienced it yet, whether it's been on the internet, books, or YouTube. Okay, that's it for now. I hope to see you in the next video. God bless you, and I'll see you around. Thank you very much. Bye-bye.